Bienvenidos nuevamente a la segunda sección de hoy sobre anticorrupción en esta conferencia anual de Marval. Como habrán visto, tuvimos algún problema en la conexión, lamentablemente, con Janos Bertot de la OCDE y no pudimos contar con su presentación más temprano. Estamos evaluando la posibilidad de que contemos con esa presentación tal vez mañana o pasado mañana, así que les haremos saber cualquier novedad en ese sentido. Ahora, en la segunda sección del día de hoy, nos toca pensar en los desarrollos que ha habido, las tendencias que ha habido en materia de anticorrupción en 3 países, principalmente líderes justamente en anticorrupción. Estamos hablando de Estados Unidos, de Francia y del Reino Unido. Nuevamente, dado el origen de nuestros invitados, vamos a tener este panel en inglés. So I'm switching into English now. We are extremely glad to have with us Philip Urofsky. Philip is a former Assistant Chief of the Fraud Section at the US Department of Justice and the current partner at Shearman Sterling. We also have Sir David Green, who is the former director of the UK's Serious Fraud Office and current senior consultant at Slaughter & May. and Stéphane Bonifassi, who is a French expert in complex white-collar crime and asset recovery litigation. We believe that this is kind of a dream team to discuss what's going on in the US, the UK, and France, at least because they know how things work in regard to anti-corruption in many other countries. But I mean, at least we are going to cover recent developments and trends in connection with the USFCPA, with the UK Bribery Act, and also with the Sapendu, let's say the most recent from these strong anti-corruption regulations. So in this regard, let me trigger the conversation by asking how COVID-19 has impacted anti-corruption enforcement from the side of governments in regard to investigations, and also from the side of companies. I mean, has COVID-19 posed new risks when it comes to corruption? So I welcome the three of you, and I ask Stéphane if you can please take the lead in addressing this question.
Thank you. It's interesting, actually, COVID-19. I come from a country where settlements in the frame of criminal proceedings were not the norm, and you know, it was plea bargaining was considered as something really bad, and basically all cases, whether people or companies accepted guilt or not, were to face trial. But because of the tools that the US have, the plea bargaining tools, but also the DPAs, there came a point where we realized in France that it was, you know, the way we were dealing with these complex cases, because international corruption cases are always complex, were not taking us anywhere, and so we introduced DPAs. COVID-19 has an interesting impact because there was resistance, although now it's in the books, it's in the regulation, DPAs are possible. There still was a resistance from some investigating judges, from some prosecutors, not to go in that direction. But of course, COVID-19 is pushing in the direction of settlements because it's so difficult to investigate, to get witnesses to come, to get suspects to come, and so I'm seeing a trend with investigating judges, with prosecutors, to quickly come to a discussion. Well, I think we should try to find a way to settle this, basically. So that's the impact I'm seeing with COVID-19 on that front.
You know, it's interesting because, I mean, the situation that you have described for France, where DPAs are some kind of weird, let's say, solution to an investigation, is similar to what we see in Argentina. It's not the natural outcome. In general, the courts expect, you know, defendants to go to trial and come up with a final decision on that case, which, as we all know, is not necessarily how things are viewed, mainly in the US. So, I mean, Philip, what can you tell us about how COVID-19 impacted anti-corruption enforcement by the DOJ? And if you have any comments on this difference that we see in regard to how DPAs and settlements in general are handled.
Certainly. So I think when COVID first hit, you know, or became global in March, things did sort of grind to a halt for a few weeks in the United States. But I think our prosecutors were more receptive to technological solutions than perhaps others were. I mean, obviously, if in the United States, you know, a lot of investigation is done cooperatively or voluntarily. So, you know, we can send, you know, witnesses can be interviewed outside of, you know, without compulsion if they choose to. if they choose not to, and we had to have a compulsory interview, with immunity and all those kind of things in a grand jury, that's more difficult. I've not heard of virtual grand juries in the United States, so that is a impediment to going forward, where if you can't obtain voluntary interviews and cooperation from subjects of an investigation. But I think fairly quickly the DOJ and the SEC, to some extent, were willing to start doing virtual interviews. They were willing to receive information digitally, which they had been moving toward anyhow. And so the ability to investigate, was changed. It was modified and adapted to the current situation, but not necessarily, at a complete halt. I think what we have seen, though, for instance, in the FCPA world, is we're not seeing a huge amount of new investigations being initiated by the government, at least not that we're aware of. We are seeing them close out and focus on previous investigations, and as you noted, we do have a practice in the United States of negotiating a resolution when it involves companies. Very rarely will a company go to trial against the government. I personally would love to have a client, and I'm asking if anyone on the phone on this conference would like to go to trial against the U.S. government. Please give me a call. I think it would be fun for me anyhow. But it's not. But it's just. But more often, companies negotiate, and that can be absolutely done, fairly easily in the new world. We do presentations to the government on a regular basis. We negotiate, we exchange documents, we negotiate terms. We can do everything, including even a virtual hearing in front of the judge if necessary to ratify the resolution if it's a plea agreement, or sign or file papers if it's a deferred prosecution agreement. So essentially what we see from the government, I think, is closing out old cases, and where there are new cases that are brought to them by companies, companies have identified issues or investigated and believe it's right to bring to the government. They're more than willing to hear the argument, and to do some confirmatory interviews by using Zoom or whatever we're using today, StreamYard. But to actually go out and initiate a new investigation, I think that's much harder for them right now.
Absolutely. It's interesting your comment about if anyone is willing to go to trial against the U.S. government, to give you a call. Many times in conversations I have, at least on this side of the world, right, in Latin America, when you see practitioners comparing the kind of enforcement you see in the U.S. of the FCPA with local laws in Latin America, many times there is not sufficient emphasis in the fact that in the US, we are talking mostly about settlements. And in most of Latin American countries, we are talking about court rulings. And that's very, very different. So, David, what can you tell us about how COVID-19 impacted anti-corruption enforcement in the UK?
Well, in terms of companies, investigations have continued. The only thing I'd say is that interviews, particularly by video, we have found unsatisfactory, but they are happening. In terms of enforcement by the government, the SFO will say publicly that productivity is the same as before COVID. Personally, I have my doubts about that. I know there is only a tiny skeleton staff in the office, and inevitably productivity will have gone down because of that. Otherwise, during COVID, there's been one DPA, that was G4S in July. So I agree that with Philip that generally speaking, COVID is a driver towards more DPAs, but we haven't yet seen them. That's not to say that there aren't some under negotiation even as we speak.
All right, so in addition to COVID-19, another, let's say, big player when it comes to enforcement, and this is more for the long term, right? Not for the present times as COVID-19, but for the long term, we have seen an evolution in international cooperation among authorities. to investigate and to enforce anti-corruption rules. Just one example among so many in this regard has been the Airbus settlement earlier this year, right before we even dreamt about having a pandemic. But what can you tell us about how international cooperation among the authorities has evolved in recent years, and where do you see that trend is going? I mean, is this expected to strengthen the anti-corruption enforcement, or do you think we have reached kind of a peak level and we are not going to improve cooperation among authorities any longer? I mean, David, if you want to kick off the answer here.
Well, I say, first of all, international cooperation is inevitable, particularly as you're dealing with large companies which have global operations. So that's just a fact of life, and we've got to get used to it. Cooperation, the SFO has found cooperation, certainly in my time, with some countries a lot better than others. And interagency cooperation within the UK itself has improved significantly. But overall, I think all one can say to that is international cooperation is crucial to global settlements, and I think it will improve. The exceptions to that, I think, obviously, is concluding a settlement which requires any kind of evidence from, say, Russia or China, where certainly, as I understand it, it's pretty hard to get evidence from there, certainly reliable evidence.
Philip, how do you see international cooperation when it comes to the DOJ? Not only the DOJ, the SEC is there as well. I mean, and you guys at the US have I would say, the longest experience in this regard.
Well, I mean, the DOJ, well, let me start with, years ago when I was in the department, we focused on informal cooperation as much as possible because, frankly, we found formal cooperation through mutual legal assistance treaty requests, or on the SEC side, memorandum of understanding. Sometimes were both cumbersome and slow, and as David mentioned, sometimes just completely unproductive. In other cases, I had one case in Hong Kong where I had to ask for a bank record, and then when I got that bank record, which would take 6 months, I'd have to then say, okay, but now I need the next account, and then the next account. And it was just not an efficient way of conducting investigation. So we would try to build informal cooperation methods. I once wanted to share information with the UK. I wound up meeting in a pub outside of Covent Garden with 2 investigators from the Ministry of Defense, and that led to cases in the United States and the UK. So, building informal relationships was important. I think now that, there is a move toward a more structured relationship. For instance, the DOJ has had a fraud section attorney who was sort of embedded in the SFO for a period of time, and the FSA, I think, as well. And that, that was, I think, viewed as a success. And then, as you mentioned, there have been other cases. The U.S. has a pretty good way of imposing significant fines, perhaps more so than other countries. So a lot of times prosecutors are more than willing to cooperate with the U.S. because the U.S. will share the fine in a very substantial way. But there have been failures or difficulties. In the Union Oil case, I think, is an example of instances in which, for whatever reason, and I don't know the underlying facts of the dispute, but very clearly, there was a problem between the SFO and the DOJ as to who was going to be able to prosecute which person and obtain what evidence. And it led to a point where I represented an individual in the periphery of that case, and my understanding was essentially the SFO and the fraud section stopped talking to each other completely. And I'm aware of another instance involving the fraud section and Germany, where I think that's also happened. So it could be, I mean, I don't want to, it could be the arrogance of the fraud section, and being a former fraud section person, I can say we are arrogant in our approach to some of this. It could also be difficulties, legal and structural difficulties in sharing information, and it could simply be, a complete, personality issues. But these all come in to make cooperation difficult in some cases, even where it's in everyone's interest to cooperate.
Absolutely. Stéphane, what will you tell us about international cooperation when it comes to the French authorities, which, at least to my knowledge, are the kind of the newcomers to this table, right? I mean, at least when compared to the US and the UK. Is this the case?
I mean, and then let me say this in front of David: is really the UK an early comer? I would debate that, right? But admittedly, the French were not early comers either. Now, I mean, the importance of international cooperation, and we are seeing this with the French DPAs, with the Airbus case, but there was another SubGen case as well, where it was a joint DPA. I think that because before adopting DPAs, we were, in France anyway, dealing with what Philip was describing, the mutual assistance request mechanisms, which were awfully slow. I mean, yes, there was international cooperation, but that was not taking the enforcement anywhere. It was really crucial for enforcers to adopt DPAs, because then it allowed French prosecutors, French investigating judges to be at the same table as their counterparts in the US, in the UK, and elsewhere. I would add to this that at the end of the day, when it comes to international corruption, I think the tone is still given by the US. And the reason why France, the UK, Germany is being active on this topic is because there is pressure coming from the US on this topic. Should that pressure drop? And actually, I would be interested in hearing Philip's views as to what's happening with the DOJ in those last years. Should that pressure drop, I think that the pressure will drop on the SFO and the French prosecutors as well. So, but anyway, the important message here is to say, if you haven't got a DPA tool, you are not at the table of international cooperation, basically.
Philip, do you agree with Stéphane that it's the US leading these efforts and somehow putting pressure on other countries to follow suit?
Well, we certainly tried our best. Look, for years I took great glee in mocking France for its lack of active enforcement of the OECD convention laws, and there has been a sea change, I think, in France's ability to bring these, and willingness. I think it was ability may be part of it, because the introduction of the DPA in France obviously makes it easier to investigate and settle cases. But there is, I think, also a issue of willingness, not just in France, but Japan would be another case. Brazil, up until I mean, plenty of countries didn't have the political will to bring these cases. And the US, I think, felt that the point of the OECD convention, particularly, and as well as the Council of Europe and the UN conventions, was that these countries would step up. That was part of the negotiation, was they would step up and bring cases against their own companies, so that there would be the famous level playing field in which US companies and French companies and UK companies wouldn't be paying bribes. When that didn't happen, or didn't happen within a reasonable period of time, I think the US authorities started going on their own. They brought a number of cases, which I'm happy to debate the actual underlying legal theories, because I think they did distort the scope of the FCPA to be able to reach out to some of these companies. But they were more than willing to prosecute foreign companies with only tangential touches to the United States, until the local governments, their home governments, would take action themselves. And that pressure, I think, did help contribute to that, and the substantial fines that prosecutors realized could be collected in these cases, I think, has led to more effective and more aggressive prosecution in other countries. Now, what are we going to do now? I mean, we're 4 years into the Trump administration, almost 4 years, 4 horrendous years into the Trump administration. And, you know, my experience, I was in the DOJ through a number of administrations, is that at the line level, at the FCPA level, it doesn't really make that much difference who the president is, or even who the attorney general is. You know, we do our job, we bring our cases, and we try to do our best job as prosecutors, and that continues. But there is obviously a huge amount of disruption in the DOJ right now. There is a huge issue of morale and people leaving in droves from the DOJ, and that leads to a loss of institutional history memory. And there, you know, and so it's possible that over time, and there's also, I'm sorry, I maybe be a stream of consciousness here, but there's also just the overall disruption in international relations, but between this administration and the rest of the world. And so the less friendly we are with other countries, the less cooperation we're going to get. And that's going to affect the ability to bring some of these cases, to obtain the evidence, to, you know, to bring cooperative cases. I think, you know, we're not seeing it yet, but if this continues, you know, I think that there will be less cooperation, less international joint cases. And then the question is whether there's that political will. Frankly, I've always expected France and the UK and Japan and everything to start bringing cases against US companies. I mean, you know, sauce for the goose and all that thing.
All right, so David, Philip mentioned political will as a key element for anti-corruption laws enforcement. You made some reference to the kind of resources that the SFO has available now during COVID-19 times. We also talked about international pressure. I mean, considering your experience for 6 years as the head of the Serious Fraud Office, and even your longer experience, you know, as an expert in this field of anti-corruption, what would you say that are the key elements that any country, not only the UK, but any country needs in order to have a reasonable, good faith fight against corruption?
Well, I think the sea change in this country that I think underlines much of what Philip has just said about UK enforcement was, of course, the Bribery Act. And the Bribery Act was really enacted because our anti-bribery laws were at that time antiquated, and there was a real feeling that we had to step up to the plate in relation to our obligations under the OECD Convention. So you've got to have decent legislation, and that, as I say, has made a huge difference. Secondly, I think one of the drivers for greater enforcement, particularly against bribery and corruption, has been, as has been mentioned, something of a reaction, and a good positive reaction, to the extent of US enforcement under the FCPA. It can't have gone without notice by European governments that the US Treasury was receiving huge sums from European companies. And I think that too was a driver. But also you've got to have the kind of enforcement structure to act effectively. And of course, the SFO is part of the civil service in the UK. It's in.
Okay, it seems we lost David. Okay, let's continue there. I mean, Stéphane, we have mentioned a number of countries through the conversation that are making big efforts or that are expected to make big efforts in regard to anti-corruption enforcement, right? We talked about the US, we talked about the UK. Which are the countries that, besides the US and the UK, you see more active in real life regarding anti-corruption enforcement?
Well, Brazil was mentioned, and of course there's been spectacular probes coming out of Brazil. I would say, and you know, it's not often mentioned, but I would say Italy is pretty active when it comes to anti-corruption, and you know, the sentencing is certainly something that you know one would have to worry about in Italy. You know, if you're the target of a probe. Interestingly, Germany was very active after Siemens. I don't know whether they have cleaned the stables or if they are not active anymore. But we are not seeing much coming out of Germany. It may be that after the Siemens shock, you know, they did get their acts together, and there must be, of course, less international corruption coming out of German companies. But I find it interesting that we are not hearing much about anti-corruption probes. Now, of course, Germany has, you know, the diesel scandal and things like that. But there again, interestingly, the tone came for that as well, came from the US. Let us mention Holland as well, the Netherlands. I mean, we've seen some pretty important cases coming out of Holland. Holland is the Netherlands. The Netherlands is a hub, right, for companies to have their seat, and so. But we've seen some interesting and large probes coming out of Holland. That's the landscape I see. Then China, but that's an animal of its own, and it's difficult to assess what's really happening there and how politically oriented it is. But that's the landscape I see.
All right. So David, sorry, we lost you there when you were in the middle of your comment on the elements for an effective anti-corruption enforcement. You were talking about the need for an enforcement structure. Maybe if you want to wrap up that idea and also tell us about which are the countries that you see more active in the world in terms of anti-corruption enforcement.
Yeah, well, it was the last point I was making in relation to enforcement was that it is always a problem for the SFO to attract the very best staff. And something that worked for me was talking close to city legal firms in London and persuading them to second people to the SFO for 1 or 2 years. That's always difficult for an associate who is looking to partnership, but in the end, it's good for the SFO, it's good for the individual, and good for the firms. In terms of enforcement, I would mention Canada, Australia, Hong Kong, Singapore, and the Dutch, as well as France.
All right, and Philip, what's your view on which are the most active countries in terms of anti-corruption enforcement? And I'm wondering if you're going to make any names regarding Latin America, because we are not hearing any so far.
Well, I was going to say something there. Look, I mean, as you know, we mentioned Brazil and Lava Jato and you know, this particularly the Odebrecht and Braskem cases there that you know, came out of the Petrobras case, and that has spun off into many countries in South America and Latin America. You know, because Odebrecht is such a enormous company within Latin America, and they had so many government contracts, and they had and so, you know, once the facts were fairly well established through Lava Jato investigation, it was somewhat easy pickings for other countries. But we're not seeing a lot outside of that area, except for, you know, the normal, you know, what we see in, you know, domestic corruption cases when governments change and scores are settled. I think outside of that, I agree that, you know, as we mentioned, Brazil, Germany was active. You know, they seem to be still active in the corporate investigations you know, of not involving corruption. You don't hear too many corruption cases coming out of Germany right now. And Italy, of course, you know, they have the any Shell case. I think perhaps Israel is a country that I'm seeing a lot of activity coming out of, looking at their own companies outward look. I mean, and that's one of the things that, it's interesting or to look at is when you see some of these countries like Singapore, for instance, the domestic enforcement is very active, but what I'm looking for in an OECD, FCPA type of thing is, are you willing to prosecute your companies for what they do outside of your country? And that's where, the China anti-corruption initiative, whether it's politically driven or not, is still mostly internally focused. They've gone after some Western or non-Chinese companies operating in China. But when you look at what the World Bank has been doing and the other IFIs have been doing, and a number of Chinese companies that have been, sanctioned or debarred by the IFIs because of corruption in by Chinese companies in World Bank and other IFI funded projects, and you don't see anything in the China that follows up on this, that's concerning. And Japan also, I mean, Japan has big companies that do a lot of business outside Japan, but you see very little business, and some, but not a lot of enforcement action in Japan against companies for activity outside of Japan.
All right, so is it correct to say that lack of enforcement by local authorities would increase the chances of the DOJ stepping in any cross-border corruption case involving that particular country?
Yes, no, that's absolutely fair, but there are structural issues. Like, it was easy enough, not completely easy, but easy enough to go over to French companies because all those French companies were listed in the United States under on the stock exchange here. So that made it subject to SEC jurisdiction just because they were listed. And then whether or not you could bring a bribery case, whether there was any jurisdictional hook for the bribery, there was always books and records and under the securities law that could be used to prosecute those companies. For the Chinese companies and the Japanese companies, there much fewer of those are listed in the United States. Some, we had the reverse listings for the Chinese companies to some extent, but very few. The big companies, the companies that have been named in the World Bank cases, don't really have that much of a U.S. presence in terms of business in the United States or being listed, and that makes it that much more difficult for the DOJ to throw its weight around the way it did with respect to French companies, for instance, or UK companies.
Okay, so when it comes to anti-corruption enforcement, Stéphane was making a reference on how new DPAs are for France, and I was also referring to how atypical these kind of settlements are for countries like Argentina. So when we look at the evolution of anti-corruption enforcement in particular, how relevant is to have actual cooperation from companies in terms of not only self-disclosure, but also in terms of sharing evidence with the authorities and trying to somehow conduct investigations under certain review by the authorities that would end up potentially in a settlement rather than in a large investigation by the courts with a full trial and all of that. So, Stéphane, what's your view on this? How relevant is this cooperation by companies and potentially self-disclosure as well?
Well, this is really an interesting question, Gustavo, because now we have Sapin 2, we have a few DPAs that have been entered into. We have companies that are aware of this. And that was not the case, right? Cooperating with enforcers, prosecutors, investigating judges in France was not the thing done. But interestingly, so I think there is a will now to investigate, and the message sent by many companies is we're willing to cooperate, and we are willing to find a solution and get rid of this problem. Some judges, investigating judges, some prosecutors are on par with that. They like that approach. They are ready to go for that approach. Some other judges, investigating judges, some prosecutors are not really ready to go in that direction. You know, there is still a bit of opposition to the mechanism of DPAs, and so for companies, it is a difficult choice to make, because am I going to get the advantage of cooperation if I go and come forward? Now, self-disclosure, I'm not seeing much of that, but if there is something happening, are they going to be willing to cooperate? I had a discussion recently with an investigating judge about, you know, my client would be ready to lead an internal investigation. And it was very difficult to engage into a dialogue. But how do you want to conduct your internal investigation? Well, Judge, I think, you know, we would need to agree on you know, a scope, a time period, keywords perhaps. So let us talk about all this and let us see. And the investigating judge, not being used to that, was not really responsive to that approach. And you know, we had to go back and forth. And at this stage, I still don't know if I'm going to be able to bring that cooperation to the table because of a lack of understanding by the investigating judge of what is an internal investigation, that tool that is coming from the US, which means that the bar and the prosecutors, the investigating judges, are used to work together. Is the trust here in France, where we've been enemies for so long? You know, it's an ongoing process. It will happen, but it's not that easy. I can tell you that.
Well, I should say I'm familiar with those challenges because that's similar to what we see in a number of Latin American countries. In the end, it's somehow importing this approach to investigations, which is coming from other traditions, right? Other legal traditions from Anglo-Saxon countries. So, David, I mean, again, you headed the SFO for a long time, and you oversaw a number of cases, and most of them included, I assume, internal investigations by companies. What is your view on how relevant it is for an enforcement authority to get cooperation by the company?
Well, it's absolutely crucial in terms of if a company wants a DPA, it has got to cooperate. I think certainly the policy here in the UK behind DPAs was that it was very much seen as an alternative to prosecution. And it is for the SFO as the prosecutor to convince a judge that it is in the interests of justice that a company should be dealt with by DPA rather than by prosecution. And if a company has failed to cooperate, that is a very difficult uphill task. I think, you know, one then looks at what does one mean by cooperation in these circumstances. And I would say, and I don't think it's changed under my successor, first of all, a self-report by the company once wrongdoing has been discovered, and a self-report at an early stage. Secondly, access to the first accounts of witnesses. Thirdly, cooperation between the investigator and prosecutor and the conduct of the internal investigation by the company. And also, I think there is a tendency by internal investigations to downplay the seriousness of a problem. That was always my experience. Every single report that came an internal investigation downplayed the extent of the problem. That actually isn't cooperation. So those elements, I would say, together describe cooperation. And I think I've explained that it is because the judge has to decide that it's in the interest of justice that a company should have a DPA. That's why cooperation is so important. Having said that, I think it is actually getting slightly easier to get a DPA. I think the bar is being lowered, if anything. And I say that for this reason, that in the latest DPA in July of this year, in G4S, which is a major supplier of services to the UK government, they did not cooperate from the beginning. And the discount they received and the financial penalty was only 40%. And that's only the second time in DPA history in the UK that the discount has been below 50%. And that was because, the judge said, of what she called the delayed nature of the cooperation. In other words, they didn't cooperate at first and only did so later on. So for that reason, I would say, if anything, the bar is getting slightly lower.
I see. So, Philip, what's your view? I mean, not only on how relevant cooperation by the companies is for enforcement authorities, but also on David's comment that he frequently saw companies downplaying the facts of the case under investigation when reporting on an internal investigation.
Well, starting with the latter point first. Yes, I've seen that. I mean, when I was a prosecutor, I've seen that. I've seen someone come in and said, "Oh, it's just a books and records violation," and and the more, and you should leave this to the SEC. It's a civil matter. It's nothing big, and we didn't. If you start off with that, if that's your first statement, you are going to face some significant headwinds. If the company comes in, they say, "Look, we did a thorough investigation. Let us tell you what we did and what we found," and this is a matter that requires some conversation with your client as well. I mean, I've had to answer that question from the client. Where is the advocacy? Who's representing us? And having to explain to the client that the first thing you have to do is establish credibility with the government and say, you can rely on our investigation because these are the facts. These are the facts. And if you do an investigation, you're not going to find any different facts. But if you work with these facts, then we can talk about how to resolve it and what the appropriate resolution is. If you come in and you're clearly trying to steer the resolution from the very, very beginning, then I think you have some, you're going to face increasing headwinds from the government and demands for more than just confirmatory interviews, which sometimes they'll do, is say, okay, we understand what you're saying, the person said, but we want to hear it directly. And that could be because they're just going through the motions of confirming your investigation. It could also reflect, skepticism as to whether you ask the questions. And I've seen the SFO's criticism of internal investigation questions. I don't think they're well founded, frankly, but at least not for my investigations, of course. But if the government suspects, it just finds that the answers you got were not credible, well, that's itself a problem for them. And they're going to go out and they may say, we want to talk to that person. We want to understand how they can possibly say they didn't see this or didn't understand this or whatever. So there is, I think, to some extent, it's a question of how you present your investigation. And do you demonstrate to them first that you did a credible investigation and that your facts are reliable? Or do you go in and you're obviously steering toward a settlement right from the beginning? DPAs in the United States are very different. And we were first in the box with them, but they're very different from what the UK adopted and I think what France adopted. DPAs and their kissing cousins and non-prosecution agreements were viewed as an alternative resolution. They were deliberately intended not to involve courts. There's no judge. I mean, judges have occasionally tried to insert themselves into a deferred prosecution because that does involve charges that are filed in court, but then are suspended, and if the company complies with its obligations, dismissed. But generally, the idea here was, because I developed some of these when I was there, was that we on the government side wanted a quick resolution. We wanted the certainty of a resolution, but we also wanted the ability to monitor what the company was doing in terms of improving its compliance procedures, improving its compliance with the law. And whether that resulted in the independent monitor or self-reporting or external auditing, whatever it was going to be, we wanted that to be effective and we wanted it to come to us at the department. We didn't feel that the courts probation office, the U.S. probation office, which is part of the court, was really equipped to do corporate probation, even though it exists under the law. But they weren't equipped to kind of do this international oversight of a company's implementation of compliance procedures and controls. And so that was the trade-off we had. We said, okay, we'll settle the company. We get the certainty of a settlement, and we get the certainty of oversight. But the company still has to admit. I mean, these are not avoidance of facts. Unlike a civil settlement, in a DPA, I think this is the same in the the company in the UK rather. The company has to admit to the facts. They can't say, oh, well, we're just doing this for a business purpose. This is neither admit nor deny settlement. No, they have to admit the facts, and they're going to pay a penalty, and they're going to agree to oversight. But we don't involve the courts. The company's benefit from that is, again, a settlement. They don't have the uncertainty of a trial. They don't have a trial that's going to go on for years, with motions and until you get on the court calendar. And then appeals and everything, they can, what we call in the United States, pull the Band-Aid off. We're done with whatever lingering oversight there is.
Yeah, I really agree with your emphasis on uncertainty, right? I mean, when it comes to Latin America, we see that uncertainty arising in many cases from new laws that may have loopholes and still very few court precedents. That uncertainty becomes the enemy of companies cooperating with the authorities in many cases. So continuing along with the topic of internal investigations, Stéphane, what would you say that are the most frequent and most crucial mistakes that companies make when conducting internal investigations?
It's I mean, there again, it's a tool that we are not familiar with, basically, and we imported it. And actually we were doing those internal investigations and not being sure of what we were supposed to do, right? And this is the reason, Gustavo, that the French bar, and I led this effort, has published guidelines as to how to conduct internal investigations. I think that there are some spectacular failures as to the way some internal investigations have been conducted. There's been internal investigations that were considered by the DOJ as not being honest, let's say. So that's a disaster. There's also been in France examples of internal investigations viewed as a way to hamper the advance of investigations conducted by prosecutors, and the clear example of that is the Lafarge case. It's not an international corruption case, but clearly the internal investigation was not seen as a proper mechanism to do things, and was seen as something to hamper the probes led by prosecutors. So I think that really the trust issue that I was talking about, the way you are doing them, the dialogue you need to have with the authorities as to how you're going to conduct them is really crucial. Not that they have to be led by prosecutors, but at least you have to let them know that you're doing this, because otherwise the questions will be asked.
David, what's your take? I mean, not only again on the most crucial mistakes made by companies, but also on Stéphane's final comment, right, about this, how relevant it is for companies conducting these investigations to have a productive dialogue with the enforcement authorities, which in the end will be reading the outcome of that investigation.
Well, I'd say three mistakes come to mind. One is once the decision to cooperate, once the company board has made the decision to cooperate with the SFO investigation, failure to provide the kind of cooperation that is required. That's the first mistake I have seen. Secondly, I would say there is a tendency not to get the terms of reference of the internal investigation right at the start. In other words, a failure to answer accurately the question, what exactly is being investigated? Otherwise, you get mission creep or you can miss the point. And thirdly, a point I've mentioned earlier, a mistake I've seen quite often, is a tendency to minimize the problem or the scale and extent of the problem. So those are the three important mistakes I have seen in internal investigations. But moving on, you ask how important is dialogue. I think it's absolutely crucial because it is a measure and a reflection of the extent of cooperation the company is offering the investigator. And it also helps the company, as has been said, the company in deciding to self-report. It is after commercial certainty for obvious reasons. And a failure to cooperate will actually extend the investigation and prolong the agony, which is in nobody's interest.
Philip, you already mentioned a number of issues arising in connection with this topic, with internal investigations, but I'm sure you can share with us a few more. I mean, which are those most crucial mistakes that companies make when conducting investigations?
Well, I think there is the issue of communication with the government is critical. I mean, and I'm not a big fan, quite frankly, despite having, when I was a prosecutor preaching the gospel of voluntary disclosure, I'm not a big fan of voluntary disclosure. I rarely advise it because I do think that handing over control, essentially it results in your handing over effective control of your investigation to the investigator. And once you're down that road, to the public investigator, and once you're down that road, I find it very hard for prosecutors to let go, to take to the position that there's not sufficient evidence to do something. And sometimes there may be some violation, there may be some internal issues, but they don't necessarily rise, in my personal view anyhow, to the level of being the proper subject of a prosecution. But of course, a prosecutor may not agree, and and ultimately, if you go in too early with a voluntary disclosure, too early before you know enough of your facts, you foreclose the end result. I mean, it's going to happen, and maybe it could have been avoided. The flip side of that is going in too late. The prosecutors do want to have a role, and they have a role in investigating and prosecuting appropriate cases. And if they feel you delayed it so long that there's been spoliation of the evidence, or people who were available to them are no longer available, or the statute of limitations has run on individuals, all sorts of reasons why they will come to you and say, why weren't you here 6 months ago? And I think that's an issue. In the US, we have a second issue, which is if you are cooperating too closely with the government, there is a developing area of case law that suggests that the government has outsourced its investigation to you, to the private, to the company. And that brings with it certain constitutional protections for individuals, such as the Fifth Amendment right not to incriminate yourself in an interview, and protection against search and seizure, and similar issues that become very complicated in a workplace setting. So my view is what companies, if they're going to make a voluntary disclosure, if they're going to go in and say we have an issue and give us some time to look at it and figure out what the story is and to do a credible investigation, you walk in with a detailed and comprehensive work plan. You're not asking for permission. You're giving the government the assurance that what you're going to do will result in a credible, factual report. And they may make some suggestions. You can take those under account, but you shouldn't, I think, become what has been described in one court decision, the pawn of the government. You still are, you're still acting on behalf of your company.
All right, so we are reaching the end of our panel. So my last question to you is, what changes, what kind of improvements would you like to see in the field of anti-corruption enforcement for the years to come? This is kind of a wish list, okay? So, Stéphane, can you please go first?
Well, I mean, it's going to be interesting to watch what the US is doing, right? So that's one thing that I want to see what's happening there, because I think that if the US is slowing down, there will be a general slowdown. Now, France has got the tools. I'm going to say something that I would like to see. I would like to see, French prosecutors going not only after French companies, but being strong enough to feel that they can go, as the DOJ did, can go after foreign companies if needed, if there is a connect to France. And actually, I'm seeing the SFO in the Airbus case, although it was also an English case, admittedly, but did it. And I think it would be good to see the French prosecutors go in that direction as well.
Philip, what's your wish list for anti-corruption enforcement?
Well, I have two things. One is sort of, what we would call inside baseball here in the United States, but the other one is more global. And starting with the more global one, I think, we talked a little bit earlier about cooperation amongst prosecutors. And ultimately, what I would like to see is an effective international enforcement regime that doesn't require or doesn't the U.S. to be part of every case. And I think that's a hard thing for the DOJ to agree to. I have seen cases where I'm like, why are you in this case? This was let's say a Dutch case involving a Dutch company and corruption in Europe. The fact that there was a dollar transaction, is that really a sufficient reason for the U.S. to be involved when there is active enforcement being undertaken by, the foreign country, just to get your piece of the pie or your, or even if you helped contribute to the resolution by providing some mutual legal assistance? I think there is when we wrote the OECD convention, the idea was that one country would take the lead, and if there was multiple jurisdictions, that doesn't necessarily mean that multiple jurisdictions had to also prosecute. The country with the most direct equity in the case, usually the home country of the company paying bribe, would be expected to take the lead. And as prosecutors and enforcement structures mature in other countries, and the political will hopefully follows that or leads it, maybe that would happen. The second point is the internal one. Is the U.S. has enforcement authorities have adopted a very, very broad view of corporate liability, which we've always had. But they've extended it now all through and down to subsidiaries, where they're holding parents because they have authority over the parents in the United States responsible for overseas conduct which the parent had nothing to do with. Yeah, and again, if there was an effective enforcement outside of the United States, maybe they wouldn't do that. I don't know, but I do feel that they are distorting the law in order to achieve an enforcement result, and perhaps as the international regime matures, maybe that won't be necessary.
All right, so David, we are closing the panel with your wish list.
Well, from 2012 until 2018, I banged on for one change. It's extremely difficult, as everyone knows, to prosecute a company under English law. The reason for that is, unlike the US, where there's vicarious liability, it's necessary under English law to identify the controlling mind within the company, someone very senior, and prove that they were complicit in the criminality. Now, an exception to that principle really was made under Section 7 of the Bribery Act, which creates the offence of a company failing to prevent bribery by persons associated with it. what I had said at the time, for those 6-7 years, was that if it is so difficult to prosecute companies, and it's in the public interest to prosecute companies now and again where their behavior is particularly egregious, then the Section 7 offence should be amended to not just failure to prevent bribery, but failure to prevent acts of economic crime. In other words, embracing all fraud offences. That, for instance, would have made prosecution of LIBOR, prosecution of banks in LIBOR rather than in just individuals, very much easier under English law. Having said that, as I say, I talked about that for 6 or 7 years. There was some interest, but then at the end of last year, we had a government with a stonk and great majority, a Conservative government, 80-seat majority, and since then we've had COVID with a huge hit to the economy. So it is, I can say, I would have thought with a degree of certainty that change is simply not going to happen. And I could add to that now as a gamekeeper turned poacher, I wouldn't want it to happen either.
All right, so we'll see how many of these wishes become true. And on that note, I want to thank you very much for being so generous to share your experience and your views with all of us. And I truly look forward to having you again at future editions of our conference at Marval. Thank you.
Thank you, Gustavo.
Thank you very much.
Bye.
Para el resto de la audiencia, estaremos reconectando mañana con el cuarto día de nuestra conferencia anual sobre compliance, anticorrupción e investigaciones. Muchas gracias.